Our collective slot's going to be dealing with full and frank disclosure, which is a phrase more bandied about than explored. So we want to do our best to change that over the next 45 minutes or so by probing what it requires of us as lawyers in two contexts. Over the last few years, we've seen two trends that we want to take in turn. Firstly, an increasing degree of rigor in the commercial context, including in the UK and BVI, as to what's required of litigants seeking ex parte relief. And secondly, an increasing focus in trust cases, where Guernsey and Jersey have led the way, of what information should be put before the court and given to other parties. The first half of the session will be dealt with by Terence Mowschenson QC and Bobby Friedman, and the second half by myself and Simon Atkinson. The two areas share some common features. They give rise to difficult practical issues about what's relevant and what's not, what it demands of us as lawyers beyond just putting before the court what we know, and keeping track of changing conditions and information up to the hearing and sometimes beyond. But importantly, they've got slightly different underlying rationales and therefore requirements. Given our desire to focus on the practical points and not get bogged down too much in the detail of the case law, combined with the desire of my co-speakers to have their faces sufficiently prominently displayed on the screen, we've taken the bold and possibly unwise approach of no slides. Instead, we'll send over a list of relevant cases afterwards. We're going to seek to keep pretty strictly to 45 or 50 minutes, save for questions. Please ask questions at any time, and we'll break to deal with them after each half of the talk. So that I'll hand over to Terry to kick us off.
Thank you, Jonathan. Well, good morning, everybody. The duty to make full and frank disclosure in ex parte applications is a trap for the unwary or over-enthusiastic applicant or legal representative. So I thought I'd deal first with some of the legal principles relating to disclosure, and then hand over to Bobby Friedman, who will deal with some of the practical problems and what happens when there is a breach of the duty, and then I will deal with recent cases. It was Mr. Justice Popplewell, that's Justice Popplewell II in FSD and Santos, who said that although the principle is often expressed in terms of a duty of disclosure, the ultimate touchstone is whether the presentation of the application is fair in all material respects. And you'll detect a theme going through the cases, because in general, in proceedings, each party has the opportunity to put his case. But sometimes, because of the urgency or the nature of the application, the relief has to be granted in the absence of a party, and therefore only the applicant is before the court. And that strikes at one of the principles of litigation and of justice, that a party has a right to be heard, and that right is an equal right to that of the opposing party. That opens the gate for error, because the enthusiastic party may not present everything to the court that would have been presented had the other party been present. In the context of commercial litigation, ex parte relief is a powerful weapon. A Norwich pharmacal order or freezing order is a draconian remedy, and the strict rules relating to full disclosure by the claimant are a recognition of the nature of the remedy and its potential for causing injustice to the defendant. If the remedy is granted, if relief is granted, the applicant gains a huge advantage in litigation if he gets a freezing order or a Norwich pharmacal order. If it's incorrectly granted, the applicant in effect falls on his face and loses a huge amount of credibility with the court, apart from usually suffering very severe adverse cost orders. The position in Guernsey about ex parte applications is the same as in England if one looks at decisions such as Hume, Matheson Securities, Channel Islands Limited. And just for the record, the position in Guernsey mirrors that in Jersey as well, which is also the same as in England. And I thought I'd just deal with the principles of full and accurate disclosure. The first principle is full and accurate disclosure. It's the duty of the applicant on a without notice injunction is to make full and accurate disclosure of all the material facts and to draw the court's attention to significant factual, legal, or procedural aspects of the case.
I think we've lost Terry for a moment. Let's just give him a second to see if he reappears. Otherwise, I'll leave Bobby to pick up.
Well, I think I might need to step in. They say don't work with children or animals, and also don't work with Virgin Media Wi-Fi, I think is the other rules we learn. You're going to be hearing again from Terry later, hopefully, assuming he comes back on, so he can pick up on some of those principles when he reappears, hopefully. What I'm going to be talking about are some of the practical problems that you may have, some particular instances where you need to consider the duty of full and frank disclosure. And I'm also going to be looking at when an injunction may be discharged for breach. So 3 particular practical problems. Firstly, Norwich Pharmacal applications. Secondly, what do you do when you're on short notice? And thirdly, how long does this duty of full and frank disclosure last? When does it come to an end? So starting with Norwich Pharmacal applications, the question is, do you have a duty of full and frank disclosure at all? Now, there are, of course, scenarios in which a Norwich Pharmacal application will truly be ex parte. That's because neither the ultimate wrongdoer, the intended defendant, or the third party who is responding to the Norwich Pharmacal application itself are put on notice. So, as you'll know, that's most commonly used in cases where there's a risk of tipping off if you tell the third party. They may tell the wrongdoer, for example. But what about when you have put a third party on notice, but the ultimate wrongdoer, the intended defendant, is not? And this most commonly arises if you're seeking, for example, information from a bank. That bank, or the third party generally, may well only take a neutral stance. They don't particularly have any skin in the game, but they do require you to go to court to get an order. Does that mean in that scenario, because there is a named respondent, you have the bank, that means you don't have to give full and frank disclosure? Well, let's go back to first principles. If we go back to the case setting out the foundation for the full and frank disclosure principles, which is the Crown against Kensington Income Tax Commissioners ex parte de Polignac, a 1917 case. Well, what the Court of Appeal said there was that it was perfectly well settled that a person who makes an ex parte application to the court is under an obligation to the court to make the fullest possible disclosure of all material facts within his knowledge. Well, all well and good. But what does it mean if there's an ex parte application to the court? So the court in that case said that that means in the absence of the person who will be affected by that which the court is asked to do. And so working from that first principle, it does rather seem obvious almost that where the intended defendant, the wrongdoer's confidential information is being sought, they are the person who is affected by that which the court is asked to do. So does that mean that therefore, if the intended defendant isn't there, you have to give full and frank disclosure? Well, surprisingly, that hasn't really been considered by the courts. It only appears to have come up in one case that I was able to find, which was between 2 companies, GoldenEye, and then the unfortunately but deliberately named Bendover Productions against Telefonica UK Limited. So a Norwich Pharmacal was sought in that case against Telefonica, which was trading as O2, the phone network. I don't know whether that's what Terry is on or not, but they were trading as O2 for the and asked for the names and addresses of customers committing alleged copyright infringement of pornographic material through peer-to-peer file sharing. Now, given the nature of this application and the material in question, it's perhaps not surprising to think that the customers whose names were going to be made public might have had a thing or two to say about whether their details should be provided. What happened, though, in that case was that Consumer Focus, which is effectively a consumer rights advocacy group under statute, intervened and gave full argument on the subject. They argued against the giving of this information. Now, the Council for Consumer Focus argued that full and frank disclosure should have been given. What the judge held in that case was that there was nothing in the case law to show that they were subject to such a duty, and it was also said that it was nonetheless an ingenious argument which might require further consideration. Now, I have to say I find that rather surprising. As I'll explain further in a moment, it's my view that one should give full and frank disclosure when the ultimate wrongdoer is not actually party to it. But nonetheless, the judge seemed to think it was ingenious to suggest that would have to be given. The point was not decided, though. That was for two reasons. Firstly, because the judge held that on the facts, because there was someone who had taken all of the arguments or who had taken an adversarial stance in the consumer group which had intervened, there was no need to give full and frank disclosure. But secondly, it was because this was at the first hearing, and the judge said that the court will assume that you've complied with your duty of full and frank at the first hearing, and then it can be raised as a ground for discharge later on. So slightly artificial. As I mentioned before, in my view, is that you should give full and frank disclosure. It's certainly the common practice that it should be given, and that is even if there is a third party, for example, a bank, who is on notice. It may be different if there is someone who is taking all of the arguments, who's taking an adversarial approach to it. But ultimately, the principle is that in the absence of the person who will be affected by that which the court is asked to do, in the words of the de Polignac case, then you should give full and frank disclosure. So in my view, you should. Let's look at short notice. What happens if you've given a day, 2.5 days notice to the other side? They turn up, they have a very experienced silk, and they have a very experienced solicitor team also appearing. Do you still have to give full and frank disclosure? Well, the answer, in summary, is yes, the duty doesn't change, subject to one small caveat. So the case in England that deals with this is a case called CEF Holdings and Mundy. Now there it was argued that the duty of full and frank was reduced because the defendants were represented on short notice. Well, what the judge said there was, well, you don't need to repeat points that have been taken by the defendant. I mean, that much is pretty obvious. So if your opponent turns up and they have already made an argument, you don't need to say it again. Apart from that, you do need to put all the points. And so, as I say, this can end up with quite an interesting scenario where you have a very experienced team on the other side who quite clearly have considered their arguments, decided how to put it. They've not spotted a point or chosen not to take it. Nonetheless, you are still under a duty as the advocate or on the side of the applicant to take all of those points. So it's not enough to think that your opponent hasn't spotted it. The point is that they haven't had the full amount of time to consider it, so you must give full and frank disclosure of everything. Now, of course, if you are on the respondent side, it does mean that you have effectively a free swing at this, because you can turn up, make the points that you want, even if you happen to be having a bad day and you've, I mean, I'm sure it would not happen to any of you, but you forget to, but you don't notice a point, then in that case, you can still rely on it. If your opponent hasn't raised it, you can still rely on it as a ground of discharge later on. And of course, the policy behind this is that otherwise, if there were a penalty for a respondent turning up on short notice, then as a respondent, you generally wouldn't do so. So, third practical issue, when does this duty come to an end? And there's a relatively recent decision in Jersey which is highly pertinent to this, the case of Turani and Turani. Now, this was an application for discharge or variation of a freezing injunction which had led to the payment of a sum into court. It was obtained in support of English proceedings, and the English proceedings were to enforce a Bahraini judgment and to set aside a transfer under the Insolvency Act in England under Section 423. Now, a couple of interesting points. One I just mentioned by the by is that it was argued there that full and frank disclosure had to be given about the litigation funding, and it was said that that was a failure because the information wasn't given. Now, the court held that actually on the facts it was relevant because where the time in which you're going to bring forth proceedings, in this case the Section 423 claim in England, where that was affected by the litigation funding, you did need to give those details. But the court did reaffirm that genuinely, unless it's actually relevant, you don't just need to give details of your funding. But going on to this point about how long does the duty last, it was interesting because there were two grounds that were raised, both related to information that had come to the applicant's attention after the original order had been granted. And to use the words of the English judge earlier, in what I would call an ingenious argument, it was it was alleged that because there had been a substantial and relevant change, the applicant still had to bring that to the attention of the court, even though it was inter partes. That was done by reference to an earlier Jersey authority, Wilkins and Hedrick. What the court held, though, also by reference to the English case of Krapanov, was that the question as to when the duty ends is one as to whether the matter has become inter partes or not. So essentially, if it is properly considered an inter partes hearing, then you do not need to give full and frank disclosure. And the court considered a scenario in which the applicant became aware later on of information that wouldn't be known to the respondent. Do they have to give full and frank of that? And the court held no. And in my view, that's absolutely right. Because let's say you seek an injunction on notice, and it's on notice right from the beginning. You tell the other side, you both turn up. Well, in that case, you don't have to give full and frank disclosure at all. It would be rather odd if you had to take points against you in that scenario. In litigation, there will always be certain things that you know that the other side at that particular stage doesn't, particularly before disclosure. And so there's no reason, in my view, why you would have to give disclosure of that, why you'd have to tell the court about that. But of course, that raises the question of what counts as a properly inter partes hearing. So of course, at the one end of the spectrum, if you walk out of court having just got your order, you've got it in your hand, and you receive an email from your client telling you something material, then of course you need to tell the court. But I think probably the touchstone is once you've served the order, and in particular, once the other side has had an opportunity to consider the order, then it's properly inter partes. It's much more difficult if you've just served it and then you get this highly important piece of information. Then, in my view, you probably should bring that to the court's attention. In terms of logistics, the easiest way to do it, of course, you can just send an email to the court and explain to the judge through that email why you think it doesn't make any difference. But it's important to bear in mind that you can't be your own judge in this. So if you get a further piece of information before you've served the order, and you think it's not material, you still have to apply the same test as if you'd known that before you went into court. So assuming that you would have been able to raise it and say to the judge, well, it doesn't matter because of X, Y, and Z, you still need to raise it with the judge. It's not enough to say, well, it wouldn't have made any difference. If ultimately that is a piece of information that properly considered on full and frank you should give, then you need to give it. So turning on to the consequences of the failure to make full disclosure, again, the Jersey case of Goldtron, which was approved in Tirani, the case that I mentioned a moment ago, reiterates the principles on this. And the court held that there's a twofold purpose to the rule, that prima facie an injunction will be discharged if it was obtained ex parte without full disclosure. So firstly, if material of non-disclosure is established, the court wants to deprive the wrongdoer of any advantage improperly obtained. So, of course, if the injunction would not have been granted, then that's obviously a key point. But it goes beyond that. The court also wants to act as a deterrent. So there is an element of punishment in there that the court, even if it might not have made a difference, the court still wants to prima facie at least discharge the injunction. As to whether the injunction nonetheless will be reimposed and whether it will be continued, it's very much a sliding scale. It's about what is in the interest of justice. So the court will look at whether, at a number of factors. So firstly, was the non-disclosure deliberate? Where the non-disclosure was deliberate, it will only be in the very rarest of cases that the court will continue the injunction. So, of course, it only reiterates the importance, as you'll all know, of why do not deliberately fail to give non-disclosure. The materiality of the non-disclosure is also important, how substantial it is. As I say, that it is not determinative. So you can have you can have a non-disclosure that would have made no difference, but nonetheless the injunction is not continued. And you can have a non-disclosure that would have made a difference, but nonetheless you still get to keep your injunction. But clearly it is an important factor. And the court will look at it all in the round, because there is a discretion whether or not to impose the fresh injunction, and it will look at it in the interest of justice. And I think we'll all know as commercial litigators that gives a lot of flexibility to judges, and in particular commercial judges, are quite likely to take into account the overall circumstances. Where there is a clear fraud, you are much more likely, even if it was a relatively substantial non-disclosure, you're much more likely to still get, for example, in the case of a freezing injunction, to get that continued. So obviously at one end of the scale, the less material it is. Obviously, if it was non-intentional, in those kind of scenarios where you've got a strong case as well, it's much more likely that you'll get to continue it. But it's a discretionary retest, and so that ultimately means that there is a bit of uncertainty there. What I've seen in practice, of course, is that this ground is often a make weight for others. So quite often, when a judge decides to refuse to continue the injunction, it may well be that they then also find against you on non-disclosures as a way of helping to make the judgment appeal proof, or vice versa. So I think Terry is back with us, so I will now hand back to him for him to continue on his section on the principles.
I'm sorry I left so abruptly. I'm afraid the entire system failed. We've got building works on either side of us here in London, and the electricity got interrupted as well. I was just on principle 1, which is full and accurate disclosure. The second principle is that you've got a duty to make inquiries, and you'll see in one of the cases I take you to that it was the failure to make inquiries that led to the injunction being discharged. The essential point about the duty to make inquiries is, if you had a duty to make inquiries and the inquiry would have revealed a fact, you're treated as knowing that fact, and you should have revealed the fact which you didn't know because of your failure to make the inquiry to the court. And the court's pretty ruthless about that. And the duty will obviously depend on the nature of the case which the applicant's making, and the order in which the applicant seeks. Principle 3, that is full disclosure has got to be linked with fair presentation. The judge has got to have real confidence in the advocate in front of them. It's not sufficient merely to exhibit numerous documents. If you're relying on a document because and you've put it in the bundle, you've got to take the judge to the document and show him the passage. And you've got to draw his attention to it and make sure he understands what the document says. And that duty applies even if the judge says he's read the papers and read the skeleton. So the moral is, I think here is, even on a Friday afternoon, when the judge is looking extremely impatient and saying, I've read everything, I'm ready to give you the order, you've got to hold him back and say you've got to take him through it, because it'll come back to haunt you if you don't. And if you have a transcript of the ex parte hearing at an inter partes hearing, and it shows that you've simply succumbed to the judge's blandishments not to take too long, you take the responsibility for it, and it'll be visited on your client. And the fourth principle is there's no distinction between the litigant's duty of full disclosure of facts and the legal representative's duty to assist the court by reference to relevant authorities and statutory provisions and practice directions, and to do so fairly. Now, you've heard what the effects of the non-disclosure are, but there are one or two recent cases, and you can see when you look at the cases how very often, I'm afraid, counsel fall into a trap. For instance, the BVI Court of Appeal, the recent decision of Thelma Paraskevades and Citco Trust Corporation. The facts are a bit complicated there, but essentially Mr. Paraskevades died in Cyprus, and the control of his operating company was split between 4 BVI companies. And there was a dispute between the widow and one child and 2 other children. And there was a row about the administration. A new administrator was appointed, and he wrote a letter to the widow about the BVI shares. And I'll just read a tiny bit of the letter, because you'll see why it's very elliptical. He said, because as far as I understand and has come to my attention, several different positions have been formulated on the subject. I would kindly ask you to inform me in writing of your position and opinions regarding this subject. That letter was written on the 3rd of January. On the 12th of April, a chaser was sent to solicitors in London in relation to that letter, but not expanding on what he was seeking their views about. And then on the 27th of April, lawyers for the administrator wrote again to the London Sisters, asking their views on the beneficial ownership of the shares. In fact, on that day, the administrator was changing the directors, the boards of the BVI companies and ultimately the trading company. And he was not telling the widow of that, quite deliberately. And the trustee who held the shares was also told not to tell her. At first instance, on the inter partes hearing, the judge set aside the injunction because although the ex parte hearing had referred to the letter of the 3rd of January, it had been referred to in a different context and not in relation to the question of the structure of the companies. What was being said was the administrator was surreptitiously changing the boards of the company, as indeed he was. But although the letter of the 3rd of January was referred to, it must have been in the context of beneficial ownership and not the structure. And the judge at first instance thought that the reference to the 3rd of January letter was insufficient, and the failure to refer to the 23rd and 27th of April letters was a serious failure. And rather remarkably, he discharged the injunctions. The Court of Appeal reinstated the judgments, the orders. They did feel there had been non-disclosure, but the fact was they were very motivated by the fact that indeed the administrator was acting surreptitiously. So they reinstated the orders. In England, in Rogachev and Goryianov, a case from Russia involving the sale of a market in Russia, an injunction was obtained, and there were a number of matters where the court was misled. Often, you could say innocently, but at times straining one's credulity a little. In this case, the applicant failed to take the judge to an advertisement in which the market had been advertised months before he made his application for the sale. So that worked against the idea of a surreptitious sale. He failed to find that advertisement because he didn't make appropriate inquiries. Also, the judge formed the view that he'd only discovered the sale in mid-November, whereas he had in fact discovered it, as the papers showed, in September. And in interchange between the judge and the barrister presenting the case, the judge said, oh, well, it was only in November. And unfortunately, counsel said, oh, yes, that's right. So although the true position was there, the court said on the inter partes hearing that the applicant was under duty to correct that misapprehension. In addition, the applicant didn't make full and frank disclosure because he didn't highlight the fact that 3 out of the 5 markets in which he was involved in a dispute of ownership with the defendant were in fact in his name, and he didn't appraise the court fully of the negotiations going on between himself and the defendant. Had he done so, the risk of dissipation would have been rather less. So the idea that the defendant was acting clandestinely was shot out of the water, and the injunctions were set aside. In Mrs. Justice Carr in Tugushev and Orlov, or another recent case, set an injunction aside where the applicant told the court that he thought the defendant would say he had transferred certain shares to a third party because he was obliged to do that when he took a public office. But he said he hadn't. In fact, had he made inquiries, he would have found the documents in which he did indeed transfer the shares. The judge described that failure, perhaps generously, as not deliberate but reckless, and the injunction was discharged. And the final case I'll take you to is Les Ambassadeurs Club and Albluewi, where really there a person who owned a casino in London, $2 million. The casino got an injunction, and the judge found that the risk of dissipation had been exaggerated by a number of factors. The first one was that the judge formed the view that the defendant had been in good standing for 20 years, whereas in fact he was a regular defaulter who paid up afterwards. He was told, the judge was told the defendant had gone to Saudi Arabia. That was true, but the problem was that he went there regularly and returned. And the judge was also misled about his connection to the jurisdiction in London, because he was told that the defendant had a pied-à-terre, whereas in fact what he did was to live in a house in Carlton Terrace, which was worth, at a conservative estimate, about £45 million, albeit held through, you'll be sad to hear this, a Jersey trust, not a Guernsey trust, but a Jersey trust. Nothing turned on where it was held, but the judge said that was all misleading, and he set aside the injunctions, because the whole picture actually took a different flavour once the true facts were there. And there's an interesting authority, which I won't take you to, called PJSC Commercial Bank at Kolomoisky, where in effect the Court of Appeal, looking at what was said to be the non-disclosure, thought there'd been sufficient disclosed. It could have been fuller, but that was just a question of degree, and declined to set aside the injunctions. And I'll now hand over to Jonathan.
Thanks, Terry. So I'm just pausing to see whether there are any questions that anyone has at this stage. Let's see. Terry looks relieved that they're...
I was worried that someone would ask about my internet.
No, not at all. Bobby happily arrogated your slot, as I knew he would. Okay, so moving on to the trust side, I'd like to start with three general points. The first is how full and frank in this context compares to in the commercial ex parte context. There's a slightly different rationale here, that the court's deciding whether it should insulate the trustee from suit in allowing it to take a particular step. And sometimes there'll be parties there with an interest in arguing against that. So it may not be ex parte. And in those inter-party situations, you're obviously not concerned with anticipating points that may be taken by an absent opponent. So there's not that dynamic to it. Equally, as I'll come on to later, the fact that the party is a trustee makes an important difference, because it opens up the possibility of a difference between what the trustee wants to put to the court and what it feels able or appropriate to give to the other parties, such as hostile beneficiaries who are convened. So in ascertaining what should be given to the court, there are 2 points. Firstly, that the court needs to be appraised of the full facts if it's to be able to decide whether to insulate the trustee from suit. And secondly, that the court is making the decision as to whether to give the insulation on the basis of what's put before it. So if you don't give full and frank disclosure as a trustee, you're risking not getting the insulation you need, because the insulation granted to you may not give you protection if a further pertinent fact emerges at a later date. Now, these matters aren't really dealt with expressly in the Guernsey VF test or the English equivalent blessing test. There was an attempt in the English Court of Appeal in Cotton and Earl of Cardigan to put a bit of flesh on the bone as to what sort of requirement this was. And the court there said, well, it's not really an obligation. It's more part of the evidential requirements for what you put before the court. That's true, but obviously that's not an attempt at an exhaustive explanation of what the requirement is, because you don't just have to put enough before the court to satisfy it that the relief is proper. You obviously can't keep things up your sleeve, to take an example. So even if you persuade them it's proper but keep something up your sleeve, you obviously failed to make full and frank in that situation. So moving on to the second general point, what do you need to give? Obviously you need to give anything that is or should be relevant to the trustee's reasoning. And that will give rise to practical questions in many cases about where you draw the line, and particularly in cases of urgency, about what volume of documentation you put before the court on, for example, the busy Friday afternoon that Terry was alluding to, and how you sensibly deploy it before the court. One question that hasn't really been focused on in much detail in the trust case law, but is prominent in the commercial case law that Terry and Bobby have been dealing with, is what happens if a document or fact emerges that wasn't known about by the lawyers, or whose significance wasn't appreciated by the client. So they've done their best, but something else turns out to be out there. Well, there's something said on that in the catchily named English case of 3 individual present professional trustees of 2 trusts against an infant prospective beneficiary of another trust, which is obviously an advert for using anonymisation of judgments as you do. And what the court said there is it may very well be right that in that sort of situation where something's out there that's not known about, but the party or its lawyers should have found it out through investigation, that the benefit of the relief could fall away. And that must be right, because why should beneficiaries be disadvantaged by a failure of the trustee or, heaven forbid, its advisors to look into the matter carefully enough? That leads into the third general point, which is what the effect is of not giving full and frank disclosure. And again, that's not something that's received much attention in the trust case law. Often the dynamic is not an absent party turning up at a return date to pick holes in a disclosure given. There's going to be opposition. Normally it's found before or at the hearing where the trustee is seeking the authorization in question. The infant prospective beneficiary case has something to say about that. It says that the benefit of the relief can fall away in that situation, but doesn't do so automatically. Which leaves the important question of what the test is for determining whether you still get the benefit of the relief in that situation. I would suggest that generally, at least in cases of innocent non-disclosure, you should ask what the court would have done had the proper disclosure been given. While a court understandably wants to hold a trustee to a high standard, there's not quite the same need that there is in the commercial cases to set deterrents against people seeking far-reaching relief against absent parties without giving the fullest disclosure. So Simon and I now want to do is to go through a couple of practical problems that arise, and Simon will take the first one.
Thank you, Jonathan. I want to turn to the first of several practical issues which might arise on a trustee application. And in doing so, I want to consider the proper role of the parties and what can happen if a representative beneficiary seeks to change or limit his or her role. And this arises in quite a common scenario, and I'm sure many of you will be familiar with these sorts of circumstances. So, you are teeing up your application to court, you identify your professional colleagues, another firm who are going to take on the role of the legal advisors of the representative beneficiaries, you negotiate the scope of the appointment, what side is each rep then going to take on a particular issue or issues. You identify a suitable person from within the class or classes of beneficiaries who are going to be bound by the representation order, and you agree the terms which clearly set out what the scope of their role will be, and the rep-bens and their legal teams start their work. But of course, what almost invariably happens is that the appointment ends up being later than ideal, the court hearing looms more quickly than originally envisaged. There's a mass of material to get through, there's questions, further questions from the legal teams. And of course, the trustees always want this to be done as expeditiously and as cost effectively as possible, of course. Now, you then end up nearing the hearing, and suddenly the representative beneficiaries say that in the time available, they haven't had a chance independently to verify the legal advice on which the trustees are relying, or they haven't taken their own advice on financial matters, again, on which the trustees are relying for the purposes of their application. And accordingly, the representative beneficiaries say that, well, they can't vouchsafe the trustee's advice. They're not in a position really to challenge it. And so they're reliant on its being correct. Even more problematically, you might have representative beneficiaries who say that, well, in the time available, they haven't had time to formulate their views on particular issues. They say, haven't had the resources, haven't had the time. And what do the trustees do in that situation when you turn up to court? Well, it's at this point that I think trustees have to think back to the purpose of the application and the professional obligations of trustees to the court. And this was explained in the Ries case and in England in the X and A case, where the court makes it clear that on a blessing application, the purpose is to satisfy the court that the proposed course of action is lawful, it's within the trustee's power, and the trustees can properly form the view that the proposed transaction is for the benefit of the beneficiaries. Since the blessing will preclude a subsequent challenge for breach of trust, the court is going to act with caution. And it's important to remember the trustees still have to satisfy the court that it should bless their actions. And so if a representative beneficiary has purported to limit his or her role and hasn't had an opportunity to undertake some task, that should be brought to the court's attention. And just because you might think that the representative beneficiaries aren't doing or haven't been able to do the job which they signed up for, doesn't mean the trustees can thereby sit back and let any subsequently disgruntled beneficiary sue the representative beneficiary for failing to spot the point. The trustees should point out the issues so the court is fully apprised. That way, if a non-representative beneficiary comes along subsequently and has identified an issue which no one else did, the trustees can't be criticised for failing to point out to the court that the representative beneficiaries might not have had the time or resources to spot the point that another beneficiary subsequently did. Now, in those circumstances, if the trustees have been open and frank with the court, then you would have had innocent non-disclosure point. And in those circumstances, as Jonathan indicated, the trustees would probably are likely to get more indulgence from the court, and so their insulation from suit is more likely to be preserved. Of course, on the other hand, if limitations have been withheld from the court, then this obviously risks undermining the very protection which trustees have gone to court in the first instance to obtain. So the short point, I think, on the answer to the first practical problem is to make sure that the court's attention is drawn to any limitations to the scope or extent of the representative beneficiary's role that practically might have arisen as a result of issues such as lack of time or resources. And with that, I'll hand back to Jonathan to consider the next practical issue.
Thanks, Simon. The second one is who full and frank disclosure has to be given to in the trust context, or as I shall slightly flippantly call it, when you shouldn't give full and frank disclosure. Another way of casting the issue is whether full and frank disclosure just needs to be given to the court in a trust case, or whether it also needs to be given to the convened parties in all cases. And it was suggested, I think rightly, in the infant prospective beneficiary case, that an important aspect of disclosure is giving disclosure to beneficiaries as well as the court, because by insulating the trustee from suit, you are giving up the ability of the beneficiaries to sue the trustee in respect of the decision to take the course of action in question. But it seems to me as a very important difference between disclosure to the court and disclosure to the parties in trust cases, that the former is the critical one because you can't derogate it, you just can't. Whereas while the second is important, it can be derogated from when it's appropriate. And the reason is, as you often come across, is that you can have situations where it's heavily against the interests of the trust to put information in the hands of some people, particularly hostile beneficiaries in litigation with the trustees, who may use it against the trust or pass it to other people who are likely to choose to do so. And as the now bailiff pointed out in the A-limited FERBs and T-limited case a few years ago, the importance of being able to give to the court full and frank disclosure and to explore issues raised by potentially hostile beneficiaries without the concern of it coming to their attention is itself part of the reason why you sometimes don't need to convene or give disclosure to beneficiaries, even allowing for the fact that you could, as an alternative, have part of the hearing in their absence. And moreover, as the AFERB case also picks up, you can have situations like when you wish to have guidance as a trustee on whether to disclose documents in foreign proceedings that the hostile beneficiary is a party to, where disclosing the information now would itself frustrate the purpose of the relief you're seeking, which in that example is to give the court the task of deciding whether you should be disclosing the information. So the sort of reasoning that emerges from those cases is obviously that people who are interested in the question of whether relief is granted should, to the extent possible, be given a proper say as to whether the relief is granted. But one needs to be careful about some of the more general statements made that parties convened or parties interested need to be properly informed and given the chance to make submissions, because there can be good reasons why that is not an appropriate course on the particular facts. So the question then becomes how one works out in practice what to give to people in those difficult categories of hostile beneficiaries or similar, how in practice you balance those competing considerations. And although that's an analogous question in some ways to in the commercial context, you're not really asking the question, is this document relevant? Normally it's its precise relevance and importance that gives rise to the difficult question of whether you place it in the hands of someone with a very different interest. So it's a different and sometimes more difficult question. One helpful practical way of dealing with it is to view the different possibilities as a sliding scale and ask yourself which sort of case you're in. So at one end, you've got the ordinary convening of a party and giving them the same body of information you give to the court. One step down, you've got convening, but not giving them all of the same information, giving them some of it. One step down from that, you've got not really giving them very much at all, and perhaps not convening them, just giving them notice and allowing them to make representations, be it orally or be it perhaps in writing. And then at the far end of the spectrum, you've got the case of not convening them at all, or giving them the chance to make reps, but through the use of Rule 35(1) of your Royal Court Civil Rules, allowing an action to be brought as a trustee without adding as parties any persons who have a beneficial interest in the trust. Now again, the infant prospective beneficiary case has something to say about this, and there, oversimplifying slightly, a beneficiary in litigation with the trustee sought disclosure of the opinions and instructions to counsel being put before the court on the beddoe. And it was held that the beneficiary should be able to see those documents, but the trustee should be allowed to salami slice the opinion by redacting the bits that showed, for example, adverse views on the merits. Now, I don't, for my part, think that sort of approach would be applied in Guernsey in quite the same way, and I don't think one should take in any event that case as saying that you need such a granular salami slicing approach in all cases. Rather, the question is a more general one to be asked in the round: have you balanced correctly the sort of competing considerations I've been talking about? Most difficult of all, it seems to me, is when you need to take the more extreme step of not convening someone or giving them any sort of notice. So one asks, when will that be appropriate? I can suggest some possible candidates, accepting that a lot will ultimately turn on the particular context of the case. So firstly, where the beneficiaries even knowing about the proceedings could cause serious harm to the trust. For example, in a situation where it could cause one of them to run off and get an injunction in another jurisdiction that could irreversibly harm the trust assets in some way. Secondly, where the beneficiaries in question are made clear they don't want to be involved at all. Although even in that situation, you still need to ask yourself the question, do you still want to convene them so that they're technically before the court? Thirdly, where the person in question is an outsider with only a personal claim rather than an incontrovertible beneficiary or someone who is claiming to have a proprietary interest in the trust assets. Obviously, in that situation of just having a personal claim, you're outside the net. And there was an authority from Cayman called X and Y a few years ago, which articulated why that you've got as someone having a personal claim to take the trust as you find it. You're just an outsider who, when you come to enforce your claim, has to do so against the trust as it then stands. So you shouldn't be involving yourself in how the trust should run, the decision it should take in the interim. The fourth case is where, although you might be able to give the beneficiary a teeny bit of information, you can only tell them so little that they're not really going to be able to make informed reps at all. Although in that case, you of course need to ask yourself, should you at least allow them to make some reps, even if they're extremely general in terms, to do what you can to allow them to put their views before the court. And lastly, in AFERBS itself, which is quite interesting, they're the beneficiaries in the foreign matrimonial proceedings had, according to judgment, made very clear their stance on joinder and the other orders that they had sought and obtained in the foreign jurisdiction, which had led to the trustee seeking directions from the Guernsey court. So it was felt that they didn't need to be joined to it, having had their say in that way, in a situation where it would be difficult for the trustee to set up the hearing in a way where it could speak freely if they were convened. So that's an interesting candidate to explore. Finally, before handing back to Simon for the final practical situation, one practical answer to a lot of the above discussion of principle that I've been going through is that in Guernsey, as in Jersey, you've got the helpful facility of a convening hearing to try to air some of these issues before the court in the absence of the potentially hostile parties. And I think that that's a very useful tool, because even allowing for the generally short duration of those hearings, unlike in many jurisdictions, you've got the ability to ask the court to sense check at an early stage whether it agrees with the trustee's approach to convening and providing information, which is to my mind, a useful facility to have, and one to be reached for in cases of genuine difficulty. So I hand back to Simon for the last one.
Thank you, Jonathan. So the final practical problem we wanted to consider in these sorts of trustee applications to court is the issue which can arise when you have a prospective representative beneficiary who either cannot or does not want to assist with the trustee application. Now, this inability or unwillingness can take one of several forms. The first sort of situation is where you have a beneficiary who is reluctant to act in a representative capacity because the decision being taken by the trustees is highly contentious, and the beneficiary in question is worried about his or her role becoming widespread knowledge amongst the beneficial classes. That's one particular issue which can arise. The second is where you have a limited number of beneficiaries within a particular class, and none of those who are within the class are interested or available to assist. And lastly, you sometimes have beneficiaries who are willing to act, but they will only do so for a fee. So what does the trustee do in each of these situations? Well, taking each in turn, the first, i.e. where you have a beneficiary who's reluctant to act because it's a contentious decision and they don't want their involvement becoming widespread and becoming known amongst the beneficial class. Well, I mean, that can usually be dealt with fairly easily by way of confidentiality orders. If it is a genuine concern, then the confidentiality regime, which a court will quite often throw over these applications, can usually keep that person's involvement anonymous. So that is practically usually fairly straightforward. The second sort of situation where you have a very limited number of people within the class, that in the final analysis is also fairly straightforward, because if nobody else is willing to act, you can, of course, get the court to appoint an advocate to act in the role. That is more common in the Channel Islands, in my experience, than it is in England, although even in England I've seen it done, and it is increasingly done, I think, where you just cannot find someone to represent a class. The third situation where you have a representative beneficiary or potential rep ben who is only willing to act for an emolument. This presents slightly more challenge, but again, the answer is, in my view, reasonably clear. It's not appropriate, or in almost any situation, it seems to me, for a representative beneficiary to be paid a fee for his or her involvement. And why do I say that? Well, it seems to me there are three reasons. Firstly, a matter of presentation. Secondly, it's a matter of consistency. And thirdly, it is a matter of comfort. What do I mean by each of those? Well, dealing with a matter of presentation, trustees do not want to be seen to be paying off beneficiaries, which is an uncharitable way of viewing it, but it is a way in which certain beneficiaries who don't act in a representative capacity might choose to construe the actions of the trustees. It's also obviously a question of whether it would be within the scope of the trustees' powers to agree such remuneration, and or whether it would be a proper exercise of those powers in any event. So it's a fraught issue if the trustees are going to start paying beneficiaries for their involvement. Secondly, it is also a matter of consistency, as I said, and that, it seems to me, it manifests itself in the following way. If you have one potential representative beneficiary who is asking to be paid, then it seems to me that if you're going to pay one, you'd have to pay all of the representative beneficiaries, because otherwise you would be favouring, as it were, one particular class of beneficiaries, one particular representative beneficiaries, and that sets up obviously a conflict as between the various classes of beneficiaries. So there is that matter of consistency. And thirdly and finally, there is a matter of comfort, and I mean a matter of comfort to the court. One has to remember what the proper role of a representative beneficiary is, and that is to assist the court in ensuring that all proper arguments are before it. It is a little bit like an amicus curiae, that the representative beneficiary is there essentially performing in a sense, a public function to assist the court by ventilating those arguments which might not otherwise be ventilated. And of course, it's deeply ingrained within courts, that they dislike the idea that somebody is being remunerated by a third party to ventilate, to come before the court and make arguments. So I think if one were to have a situation where you have a representative beneficiary being paid, then you may find courts hostile to that particular course of action, even assuming it was otherwise a proper proper discharge of the trustee's powers. So the short answer is, it seems to me, no emoluments for potential representative beneficiaries. And with that, I come to the conclusion of the practical problems that Jonathan and I wish to canvass, and so I'll hand back to Jonathan.
Thank you very much, Simon. I'm looking down at the question and answers pane, but I'm seeing it empty. So all that remains is to thank you very much for watching. If you stuck with us this far, you can plainly well handle the hard truth of full and frank disclosure. And to end on a note of optimism, we hope to see you all in the near future. Thank you very much from all of us.